So the reconsideration mechanism is a new rule that is set to be introduced from the 22nd of July 2019 that allows the parties to a case, that is either the Secretary of State or the prisoner, to check that our decisions have been made correctly. So the Parole Board make very difficult decisions. We make 25,000 decisions each year, and it's important that we get those decisions right. This mechanism provides an opportunity for the public and indeed other parties to be assured that we are making the right decisions in those cases. So under the new mechanism, either the Secretary of State or the prisoner can apply to the Parole Board within 21 days of the decision being issued to ask that a decision be reconsidered. So a victim who's affected by a Parole Board decision should be contacting officials on behalf of the Secretary of State to make representations as to why there may be concern about a particular decision, and the Secretary of State can then consider that and make a reference to the Parole Board. So the reconsideration only applies to people serving sentences which are eligible for a parole review. It includes all cases other than those who are recalled on a determinate sentence. So as soon as the Parole Board receives an application for reconsideration, a member of staff on the new team will gather the necessary information and then pass that information to a judicial member of the Parole Board who will consider whether the threshold of reconsideration is met in that case.
The grounds for reconsideration will be the same as grounds for judicial review of a parole decision in the High Court. These are defined in the rules as procedural unfairness or irrationality. Procedurally unfair will include an error of law, for example, applying the wrong legal test for release. It will also include procedural unfairness, which means that the prisoner hasn't had a fair hearing. For example, the prisoner not being told all the information on which the Parole Board makes its decision. Irrational means a decision which no reasonable panel could have made. It's a very high bar. It will not be reached simply because one of the parties is not happy with the decision. If the conclusion is reached that the hearing was procedurally unfair or the decision was irrational, then the reconsideration panel may refer the matter back for a further parole hearing. If the reconsideration application is rejected, then the original decision will stand. In either case, written reasons will be given to the parties within a short period of time.